Okay, so we're going straight into corporations. A corporation is a separate juridical entity. It's a separate juridical entity, meaning the corporation is separate from its officers, directors, and shareholders. Okay, in order to begin its corporate existence, the incorporators must file the articles with the Secretary of State. Corporate existence begins upon filing. If a person acts with actual knowledge, if a person acts with actual knowledge that the articles of incorporation have not been filed, he is jointly and severally liable. So he is jointly and severally liable for all liabilities incurred while so acting, unless the third party also had actual knowledge that the corporation had not been created. The incorporators are one or more persons who deliver the articles of incorporation to the Secretary of State for filing. And the articles of incorporation must contain. Now, under the statutes, there's two parts to this statute. And the first is mandatory provisions in the articles. The second is discretionary. I think your best bet here is to memorize the mandatories. And pretty much everything else is discretionary. So the mandatories are first the corporate name. I'm getting weird. The corporate name, which must be distinguishable from other corporate names. The name must contain language indicating that the entity is a corporation, may not imply any illegal purpose, and may not imply a connection with a state or federal agency. So for distinguishable, that could be the presence of a comma or a hyphen is sufficient to be distinguishable. The next is the address of the initial principal office. The number of authorized shares. Next is preemptive rights. And if you go down to the footnote, the only opt-in provision mentioned in this section of the Florida statutes is preemptive rights. Cumulative voting and par value are also opt-in provisions, meaning that if the corporation has them, their presence must be noted in the articles of incorporation. Okay. Next is the address and name of the initial registered agent. And finally, the name and address of each incorporator. The articles may contain, first, the names and addresses of the initial directors. Second, a purpose statement. Third, any provisions regarding management. Fourth, corporate powers, par value, and any liability of shareholders for the debts of the corporation. The next section we're going to talk about is ultra vires. Under Florida law, a corporation can be formed for any lawful purpose. So, except under very limited circumstances, except under very limited circumstances, the validity of a corporate act may not be challenged as being beyond the corporation's power. A corporate action, may be challenged first by a shareholder to enjoin. So again, that's by a shareholder to enjoin the action. Second, by the corporation itself against a current or former officer. Third, by the Attorney General to dissolve the corporation or enjoin the action. So keep in mind there with the shareholders that the relief is injunctive in nature, right? Okay, so powers. A validly formed corporation has all the powers of a natural person. This includes the right to sue, lend money, make charitable contributions, or make political contributions, limited, of course, by any applicable campaign finance limits. Charitable contributions may be made for, among other purposes, public welfare, scientific or educational purposes. They seem to like to ask questions about corporations making charitable contributions. So just keep in mind they can. Shares and free transferability. Ownership interests of the corporation are divided into shares. The shares are the units in which the proprietary interests in the corporation are divided. The number of authorized shares. So again, that's the number of authorized shares is the total number of shares that the corporation is authorized to sell. So authorized shares are shares issued plus shares outstanding. Second, the number of issued shares. So the number of issued shares is the number of shares which have been sold. Okay. Next, the number of outstanding shares is the number of shares which are actually currently owned by the public. And treasury shares are authorized and issued but are not outstanding. So we'll do a brief example. Corporation X has 500 authorized shares. It sold 300 shares on June 7, 2014, reacquired 200 of those shares. Sorry. On June 15, 2014. It then sold 100 shares on June 30, 2014. So how many shares are authorized? Well, the authorized are 500. So that would be stated in the Articles of Incorporation. How many shares are issued? The issued shares are 400 because it initially sold 300, then sold another 100. So if you think of issued shares, sort of think of used shares, right? They're in the hands of the public. How many shares are currently outstanding? There's 200 shares outstanding. Okay. Next, a corporation may have classes of shares. Each class must be distinct. And all shares in the class must have identical preferences, limitations, and relative rights. There must be at least one class of shares with unlimited voting rights. So at least one class with unlimited voting rights. And at least one class of shares with unlimited economic rights. And what we mean when we talk about economic rights are the rights to receive the net assets upon liquidation. Okay. Shares may, but do not have to be evidenced by a certificate. If a share is not evidenced by a certificate, the issue must be accompanied by an informational sheet. The informational sheet must set forth first the name of the issuing corporation, second, the name of the person to whom issued, third is the number and class of shares, and fourth, if the corporation has different classes of shares, the designations, relative rights, preferences, and limitations must be summarized. So free transferability is our next fill in the blank there. So free transferability generally indicates an ability at any time to sell one's shares. However, a corporation can restrict the free transferability of shares, but the restriction must be conspicuous. So it must be conspicuous on the certificate or info sheet which accompanies the shares. Conspicuous for these purposes is generally bold or italicized in a different font. Anything that makes it sort of stand out. So an example of a restriction on free transferability could be that the purchaser may not sell within the first 6 months of acquisition, or that the corporation or other shareholders have a right of first refusal to purchase the proffered shares. A purchaser for value will not be bound by a restriction of which he has no notice and which was not stated on the certificate or info sheet. So next we'll consider preemptive rights. Again, if a corporation has preemptive rights, the presence must be contained in the Articles of Incorporation. A preemptive right is the right to maintain a proportionate amount. So it's the right to maintain a proportionate amount of unissued shares upon their issuance. Okay. A preemptive right may be waived. A waiver, if in writing, is irrevocable, even if there is no consideration. Yeah.
Does that have to be in writing?
Yes. It's revocable if it's not in writing. So. So the best practice would be to always have them in writing. Even if otherwise available, a shareholder does not have a preemptive right to purchase first shares issued as compensation. Even if otherwise available, a shareholder does not have a preemptive right to purchase shares issued as compensation or shares issued for consideration other than money. So next we'll talk about shareholders. Shareholders are the owners of shares of the corporation. Shareholders can purchase their shares for any consideration, including money, promissory notes, services performed, future services if evidenced by a written contract, and other securities of the corporation. Okay. The board of directors determines the adequacy of the consideration received. Okay, so if you're talking about cash or a promissory note, you're not really worried about the adequacy of consideration, but the board would have to value services performed or the future services evidenced by a written contract. Okay, shares may be acquired by subscription. A subscription for shares is irrevocable. So a subscription for shares is irrevocable for a period of 6 months unless the subscription agreement calls for a longer or shorter period, or all subscribers agree to revocation. Notice that's a unanimous requirement if we're going to revoke. Okay. To be enforceable, a subscription agreement must be in writing and signed by the subscribers. Shareholders may receive distributions. A distribution is a direct or indirect transfer of money. So, a distribution is a direct or indirect transfer of money or other property, except the corporation's own shares, or the incurrence of indebtedness by the corporation to or for the benefit of shareholders. In order to make a distribution, any distribution must be authorized by the board. So it must be authorized by the board. The record date for any distribution is the date the distribution is authorized. A record date is generally the date on which the corporation determines the identity of the shareholders and their interests. So for instance, if a distribution is declared and then somebody sells their shares, the person who owned it on the record date is still entitled to the distribution. Okay. There are two tests for making a distribution. First is equity and solvency. Under the equity and solvency test, it demands that the corporation must be able to pay its debts as they become due in the regular course of business. The second test is the balance sheet test. The balance sheet test requires that the total assets must be at least equal to the sum of the total liabilities plus the amount needed to satisfy any preferential rights. Okay. A share dividend A share dividend is a distribution of shares on a pro rata basis and without consideration. A share dividend is not required to meet either the equity and solvency or balance sheet tests. Shareholder meetings. Annual meetings may be held in or out of the state. A special meeting is limited to the purpose set forth in the notice. And notice of meetings is at least 10 days, not more than 60 days.
I'm sorry, can you repeat
Yep,
that?
at least 10, not more than 60. And keep in mind this is for shareholder meetings as opposed to board meetings. Okay. Voting. Generally, shareholders are entitled to one vote for one share. And shareholders may vote by proxy. A proxy is valid for up to 11 months and is generally revocable unless the proxy document states it's irrevocable and the proxy appointment is coupled with an interest. An interest for these purposes may be a pledge, contract for sale, for example. An irrevocable proxy becomes revocable when the interest it is coupled with is extinguished. A quorum is required for any action. So again, a quorum is required for any action. A majority of votes entitled to be cast at a meeting constitutes a quorum. A quorum cannot be broken by a shareholder leaving. The required number from a quorum may be reduced from a majority to not less than 1/3. Okay, continuing our discussion of voting, cumulative voting is our next topic. So if cumulative voting is authorized, a shareholder may cast as many votes for directors as a shareholder has shares, multiplied by the number of directors to be elected. So again, that's cumulative voting. And cumulative voting encourages minority representation. Encourages minority representation on the board. The effects of cumulative voting can be defeated by specifying classes for directors or reducing the number of directors. So voting arrangements. First are voting trusts. A voting trust separates legal and beneficial ownership, and shares are actually transferred to the trustee. The trustee is under a duty to file a list of participating shareholders with the corporation. Next voting arrangement is shareholders' agreements. And shareholders' agreements are private contracts, which are specifically enforceable between shareholders. Note the specifically enforceable part of this. Essentially, this would come down to a dispute between two people on how to vote. And if they have a shareholder agreement, the court will specifically enforce the terms of that arrangement. So we'll force the shareholder to vote the way the agreement specifies. Next, derivative actions. In order to bring a shareholder derivative action, the person must have been a shareholder when the transaction complained of occurred or have become a shareholder through operation of law. For instance, inheritance. So a corporation can't do something or have some scandal and then you acquire shares in order to bring this type of action. You have to be a shareholder when the transaction occurred. The complaint in a derivative action must be verified. So it must be verified and allege with particularity the demand made to get the board to act. This is known as the universal demand requirement. So if a court finds that the board or advisory or special litigation committee made a reasonable investigation of the shareholder's issue and concluded in good faith that maintaining the action would not be in the best interest of the corporation, the action will be dismissed. Once brought, a derivative action may not be discontinued or settled without court approval. So next, fundamental changes. In the event the corporation is undergoing a fundamental change, for example, merger, sale of all assets outside the regular course of business, share exchanges, consider who will be affected. The affected party is the party who gets to vote on the change and who may have appraisal rights. So considering appraisal rights, they are not available. So appraisal rights are not available if the shares are listed on the New York Stock Exchange or the American Stock Exchange, or there are at least 2,000 shareholders. So at least 2,000 shareholders and $10 million in value. Note that's a conjunctive test, so you need both of those. Okay. A corporation must give shareholders notice of the existence of appraisal rights in the notice of meeting. A shareholder wishing to assert his appraisal rights must deliver notice of intent to demand payment. If the action is affirmatively voted, the corporation must send notice of the approval within 10 days and give shareholders a form on which to assert their appraisal rights and make an offer of value. The shareholder must execute and return the form to the corporation with their demand of payment or accept the corporation's offer. If the corporation disagrees with the shareholder's assertion of value, it must submit the matter to the court within 60 days. Okay. So our next corporate characteristic is centralized management. The management of the corporation is centralized in its board of directors. The board of directors must be made up of individuals. A director must be at least 18 years old and is not required to be a Florida resident or shareholder of the corporation. A director may be removed with or without cause. And a director may resign by delivering his written resignation to the board. The board sets its own compensation. And this is not considered self-dealing. It sounds like the very definition of self-dealing, so just it isn't. Regular meetings of the board of directors may be held without notice of the purpose of the meeting, and a special meeting must be preceded by at least 2 days' notice of the date. So at least 2 days' notice of the date, time, and place. The notice here need not describe the purpose of the meeting. So contrast that to shareholders' meetings, right? Shareholders' meetings, you need at least 10 days, not more than 60, and special meetings must contain the purpose, right? For directors, it's different. They need at least 2 days' notice of a special meeting and no need to describe the notice, or the purpose, excuse me. For any action to be effective, a quorum must be present at the meeting to vote on the action. A quorum generally consists of a majority of the board, but the articles may authorize a quorum to consist of less than a majority, but no fewer than 1/3. So it's the same rule as we had for shareholders. Okay, it can be less than a majority, but not less than 1/3. Directors must act in good faith. Okay. With the care of an ordinarily prudent person, in like position, under similar circumstances, and in a manner that he believes to be in the best interests of the corporation. Okay. Notice that standard, the ordinarily prudent person. So it's not an ordinarily prudent business person, right? It's just your average individual. In making his decisions, a director is entitled to rely on the opinion of experts, for instance, accountants, attorneys, officers, employees. It does not include a psychic. There's just a case on that. So a psychic is not an expert. In making decisions, a director may consider the long-term prospects of the corporation. The long-term prospects. The interests of the shareholders. The social effects of the action taken, which I would argue may get somebody removed without cause. But they can consider the social effects of the action taken, the communities in which the corporation operates, and the economy of the state and nation. A director is not personally liable for monetary damages unless, first, the director failed by action or omission to perform his duties, and such breach or omission constitutes, first, a criminal act, second, a transaction from which the director derived an improper personal benefit. That's improper personal benefit. Third, in a derivative action where the breach or omission constituted conscious disregard for the best interest of the corporation or willful misconduct. Or fourth, the breach or action constituted recklessness or was committed in bad faith or with a malicious purpose. Now, it seems to me when they're trying to get you to think somebody acted recklessly, it's pretty reckless what they're illustrating to you. I don't think that would be a close call in a question. Okay, the exception to centralized management. In a corporation of 100 or fewer shareholders, an agreement may be made to change the governance scheme of the corporation, even to get rid of the board. If such agreement is entered, it must be set forth in the articles or made by unanimous agreement of the shareholders. Okay. An action by a director, which would otherwise be a conflict of interest, will not be improper if first, the relationship or interest is disclosed, and the contract is ratified without counting the vote of the interested party, although such interested party may be counted for quorum purposes. Second, the action is ratified by shareholders after disclosure. Or the contract or transaction is fair at the time it was authorized. Okay, liability for improper distributions. A director who makes a distribution which violates either the equity insolvency or balance sheet test is personally liable to the corporation to the extent that the distribution was improper. So not for the entire distribution, just the extent to which it would have been disallowed. Okay. Limited liability. The liability of a shareholder for corporate action is extremely limited. A shareholder is obligated to pay full consideration for his shares. And the veil of the corporation may be pierced, thus making the shareholder individually liable for the debts or liabilities of the corporation if the shareholder has participated in fraud or illegal conduct which has led to the debt or liability. Okay. So now we're going to briefly consider not-for-profits. In a not-for-profit corporation, first we'll consider the articles of incorporation. The required content for those articles are the name of the corporation, the street address of the principal office, the purpose statement, and that where it says statement provided for the method of electing directors should have been the next bullet point, but it's a typo, so just consider that the next line down. So the purpose statement. Next, the statement provided for providing the method for electing directors. Next, any provision limiting the corporate powers otherwise provided by statute. The street address of initial officers and name of registered agent, and the name and address of each incorporator. And notice here particularly the purpose statement, right? In our for-profit corporations, you don't need to have a purpose statement in your articles. Permissive content of the articles includes first, the names and addresses of initial directors. Second, provisions regarding regulation of internal affairs. Next, the manner of termination of membership. It's a manner of termination of membership. Any rights upon termination. the transferability or non-transferability of interests, and the distribution upon liquidation or dissolution. A not-for-profit can be organized for any lawful purpose, not for pecuniary profit. Okay, distributions. A corporation may not make distribution to its members, directors, or officers, but may pay compensation. Distribution may, however, be made upon dissolution. Now, the compensation question is important. Generally, the compensation of executives in a not-for-profit is scaled to other similarly situated directors or executives. So, for example, the board of the hospice of Palm Beach County, I think the president made $400,000 last year, which had a lot of people in an uproar. But when you compare the size of the not-for-profit compared to other similarly situated and serving similar populations, it began to seem reasonable in that context. Okay? A not-for-profit may purchase back its memberships if after the purchase the balance sheet and equity and solvency tests are met. So members. This chapter of the Florida statutes refers to holders of an interest as members rather than shareholders. So members have no voting rights except those as set forth in the articles. Liability on the part of the members is limited to dues, assessments, or fees. Interests are generally not transferable. And resignation of a member does not relieve the member from obligations that arose prior to resignation. A member may only be suspended or terminated pursuant to a procedure that is fair and reasonable and carried out in good faith. With respect to directors, the board must consist of at least 3 individuals. Contrast that to our for-profit corporations. The board can be made up of any number of people. Okay, so that's our consideration of not-for-profits. I don't focus on them very much because a lot of it is similar to for-profits. So I tried to highlight the places where they differ. So let's go into partnerships. A partnership is an association of 2 or more persons. Two or more persons to carry on as co-owners a business for profit. A partnership is a separate juridical entity that can sue and be sued, can hold property, but is a pass-through entity for tax purposes. The partnership statutes are default rules. The partnership agreement is a governing agreement. However, a partnership agreement cannot, first, change any filing requirements. So change any filing requirements. Second, eliminate access to books and records. Or third, entirely eliminate the duty of loyalty. So notice the standard there, it's an entire elimination, so it can limit it pretty heavily. Formation. A partnership is formed when the definition is met, regardless of the intent of the parties. The following factors are not by themselves sufficient to find a partnership. First, holding property as joint tenants. So holding property as joint tenants, tenants in common, tenants by the entirety, joint property, community property, or as part owners, or sharing of gross returns. However, where profits are shared, one is presumed to be a partner, unless the profits are received as a payment on a debt, for independent contractor services, or as rent. Okay. Partnership capital is made up of contributions by partners. Property can be acquired by the partnership. Property is partnership property if first acquired in the name of the partnership. Second, acquired by one acting in his capacity of partner. Property is presumed to be partnership property. Property is presumed to be partnership property if it is purchased with partnership assets. property is not partnership property if it is acquired only in a partner's name, even if the property is used by the partnership. The partnership owns partnership property. The partners do not own it as co-owners. Let's talk about agency for a moment. Each partner is an agent of the partnership. An act of the partner in the ordinary course of business binds the partnership. An act of a partner outside the ordinary course of business binds the partnership if the partner acts with authority given by all other partners, or such action is authorized in the written partnership agreement. So, a partner's liability. A partner is personally liable for all partnership obligations. However, there is no personal liability for debts incurred by the partnership prior to that person becoming a partner. A judgment against the partnership is not by itself a judgment against a partner. A judgment against a partnership may not be satisfied from a partner's assets unless there is also a judgment against that partner. So purported partners. A purported partner is liable where he represents or allows himself to be represented as a partner to any third party who relies on that representation. Partner rights and duties. Each partner has a partnership account. So each partner has a partnership account consisting of money and property contributed and distributions made by the partnership, less liabilities distributed and shares of partnership losses. Each partner has equal rights in management. And each partner can only use partnership property to benefit the partnership. Each partner is entitled to reasonable compensation for services in winding up, but not compensation for services performed for the partnership. Decisions within the usual course of business are by a majority. Decisions outside the regular course must be unanimous. A person may only become a partner upon the consent of all the partners. And a partner is not entitled to receive distributions in kind. Each partner has the right to access books and records, including the right to inspect and copy. Standards of conduct. First, loyalty. A partner must account for any personal profits. So a partner must account for any personal profits received in connection with partnership business. A partner may not deal with the partnership in an adverse way. And a partner must refrain from competition with the partnership. So with respect to the standard of care, a partner can't act in a grossly negligent or reckless way or with intentional misconduct. A partner owes a duty of good faith and fair dealing. So actions by partnership and partners. A partnership can bring an action against a partner for breach of the partnership agreement or for violation of a duty owed, where the violation caused harm to the partnership. A partner can bring an action to enforce his rights under the partnership agreement or to enforce other rights under this act. A partner can only transfer his economic interests in the partnership. So he can only transfer his economic interests. And this means his shares of profits and losses, his rights to receive distributions, but not his interest in management. Okay, so dissociation. Events of dissociation. First, a partner can dissociate by giving notice of his express will to immediately withdraw. Second, a partner can dissociate upon the occurrence of an event specified in the partnership agreement. Third, a partner can dissociate by being expelled. So you can dissociate by being expelled by a unanimous vote of the other partners if it is unlawful to carry on with that partner or if the partner has transferred all of his transferable interests. So wrongful dissociation. A dissociation is wrongful if it is in breach of the partnership agreement. Or if before the expiration of the term a partner withdraws, the partner is expelled by judicial order, or a partner is a debtor in bankruptcy. The effect of a partner's dissociation, the partner's right to participate in management. So the partner's right to participate in management and conduct terminates. the partner's duty of loyalty terminates. But the partner's duties of care and loyalty continue for transactions occurring before the dissociation. A dissociated partner can remain liable on transactions occurring up to 1 year after the partner dissociates, so up to 1 year, if first the other party believes he is still a partner and did not have notice. However, the dissociated partner can file a notice of dissociation, and then he will remain potentially liable for 90 days. Dissolution: a partnership at will dissolves when a partner withdraws. A partnership for a definite term dissolves within 90 days of a partner's dissociation by death or wrongful dissociation. Dissolves where it is the express will of all partners to wind up. It's the express will of all partners to wind up. Or dissolves at the expiration of the term, dissolves at the happening of an event specified in the partnership agreement, or dissolves on application of a party, and it is judicially determined that first, the economic purpose is likely to be unreasonably frustrated, or it is not lawful to carry on with the partner, or it is not reasonably practical to carry on pursuant to the partnership agreement. A partnership continues until it is finished winding up. However, the partnership can waive its rights to wind up and terminate the partnership if first the partnership resumes business as though the dissolution never happened. The failure to wind up will not adversely affect a third party. Okay. So now limited partnerships. Generally, a person can be both a general and limited partner, with his duties dependent upon which capacity he is acting. A limited partnership has a distinct existence. A certificate of limited partnership must include first the name of the limited partnership. So the name of the limited partnership. The name may contain the name of any partner, including a limited partner. And the name must include some indication of its limited status. So LP or limited or words to that effect. The name and business address of each general partner. Whether the partnership is an LLLP, and where there has been substantial compliance with these requirements, the document is effective when filed. The Records Office. The limited partnership must designate and maintain a designated office in the registered agent and registered office. The Records Office must contain a current list showing the full name and street address of each partner and separately identify the general and limited partners. Must contain copies of filed documents, copies of the last 3 tax returns, and a copy of any partnership agreement and all amendments thereto. The partnership agreement. This governs the relationship among the partners and between the partnership and partners. The partnership agreement cannot first vary the power to sue and defend in its own name. Second, vary the applicable law. Third, vary the maintenance and signing requirements. Fourth, restrict the right to information. Fifth, eliminate the duty of loyalty of the general partner. However, it can identify specific types of activities that do not violate the duty of loyalty. Sixth, it can't unreasonably restrict the duty of loyalty of the general partner. Limited partnerships, unlike general partnerships, can carry on not-for-profit activities. Because remember the definition of a general partnership, right? 2 or more persons to carry on a business for profit. Contributions. The form of contribution can be any pecuniary benefit, including money, services performed, promissory notes, other agreements to contribute cash or property, and contracts for services to be performed. The obligation to contribute shall be in a record signed by the partner. The obligation to contribute shall be in a record signed by the partner. Performance is not excused by death. So performance is not excused by death, disability, or inability to perform. The death thing, I've seen a lot of questions on that. The claim would be against the estate, and it would be a valid claim, as long as it's timely made. Profits and losses are allocated on the basis of the value of contributions. All general partners are jointly and severally liable. So all general partners are jointly and severally liable, but not for obligations arising before they became a general partner. The limited partnership itself may be liable for loss or injury occurring as a result of a wrongful act or omission or other actionable conduct of a general partner acting in the ordinary course of business. The limited partner's liability. The obligations of the limited partnership are not the obligations of the limited partner, whether in contract or tort, even if the limited partner participates in management. The rights of partners. The limited partner has no power to act for or bind the partnership. And the limited partner can inspect and copy documents after 10 days' notice. No particular purpose is necessary with respect to the required information. With respect to information on the state of activities or the financial affairs of the limited partnership, they must have a purpose directly connected to the limited partner's interest as a limited partner. The limited partner must make a request describing the records sought with reasonable particularity. And the information sought must be related to the purpose described. Okay, management rights of general partners. Each partner has equal rights in management. And decisions are generally made by a majority of general partners. Some decisions require the consent of all of the general partners. These include amendments to the partnership agreement, amendment to the certificate of limited partnership, admitting a new general partner. So admitting a new general partner, admitting a new limited partner, expelling a limited partner, or dissolving the limited partnership. And finally, approving a merger or conversion.
You need that for the expelling of a general partner.
That's generally by majority unless the partnership agreement provides otherwise.
Oh, by majority? Okay.
Yeah.
Oh, I see.
Each general partner has the right to inspect required information and other information relating to the activities and financial condition of the partnership. Distributions in a limited partnership. A limited partnership may not make a distribution in violation of the partnership agreement. So in violation of the partnership agreement, or if the equity and solvency test is not met. Or if the balance sheet test is not met. A general partner who consents to a wrongful distribution is personally liable to the limited partnership to the extent the distribution was wrongful. So just like a board of director, or a director, excuse me, personally liable to the extent of the wrongful distribution. So dissolution and dissociation. You must file a certificate of dissolution. The certificate must include the name, the date of the initial filing, and the reason for the current filing. A limited partnership is dissolved upon first an event specified in the partnership agreement. Second, the consent of all general and limited partners. With respect to winding up, after dissolution, the limited partnership continues only to wind up, to discharge its debts, file a statement of termination. Now, with respect to derivative actions in a limited partnership, a partner need not first make a demand on the limited partnership if he can prove the futility of making a demand. So remember, with your corporations, that's a universal demand requirement. You always have to make a demand. Okay? An annual report must be filed with respect to limited partnerships. And with respect to erroneous belief, if one believes in good faith that he is a limited partner, he is not liable for any obligations of the limited partnership simply by making an investment, by receiving a distributions, or by exercising the rights of a limited partner. However, he may be liable to a third party who believes he is a partner, and this belief is in good faith. Okay. Next, limited liability companies. The new LLC Act became effective January 1st, 2014, and changed a lot of what we had. It's an okay act. Was that a boo?
A little from column A, a little from column B.
Yeah. I don't know. I think it's okay. LLCs could previously have a managing member. The concept has been deleted. The term has been clarified so that it no longer makes the LLC manager managed. The general default rule is that the LLC is member managed, and all members have apparent authority to bind the LLC. Yeah. Sure. The general default rule is that the LLC is member managed, and all members have apparent authority to bind the LLC. So in the past, if you prepared an operating agreement that had a managing member, essentially now you got new business because you have to go back and change it if they want that person to still be the manager. So it's good for work. The definition of member has been changed to permit a member to have voting or management rights without being entitled to any distributions. Next, the term transfer is more broadly defined to apply to any assignment, sale, gift, encumbrance, transfer by operation of law, or other transfer of a member's interest. A transferable interest is limited to the right to receive distribution. So again, a transferable interest is limited to the right to receive distributions. LLCs are governed by operating agreements, to which the laws of contract generally apply. The operating agreement can be written or oral. And note, the term operating agreement presupposes the existence of the entity. So pre-formation agreements are not operating agreements. The LLC itself can enforce the operating agreement. And the statutory provisions regarding operating agreements are primary in evidencing the relationship of the members to each other and to the LLC, the rights and duties of managers and the activities and affairs of the company. The LLC statutes are default rules. There are non-waivable statutory provisions. We'll address some of them coming up. There are certain provisions authorized unconditionally and some limited to being, quote, not manifestly unreasonable. Yeah. We don't have enough cases to really figure out what not manifestly unreasonable means yet, but so we'll talk about not manifestly unreasonable here coming up. Confirms that the operating agreement may set forth specific penalties or consequences for failure to comply. Non-waivable provisions in operating agreements. First, judicial dissolution. So in your operating agreement, you can't forbid a judge from dissolving you. Next, unreasonably restrict the right of a member from bringing direct action against the company, another member or manager, or maintaining a derivative action. Can't unreasonably restrict the inspection and copying of records. The operating agreement may not exonerate a person from liability for conduct which involves bad faith, willful or intentional misconduct, or a knowing violation of the law. Okay, so the not manifestly unreasonable standard is applied with respect to the elimination, alteration of the duties of loyalty, care, good faith, and fair dealing. A court must decide as a matter of law whether a term is manifestly unreasonable. The court may invalidate only if it is readily apparent that first, the objective of the term is unreasonable, or the term is an unreasonable means to achieve the provision's objective. The operating agreement is generally not subject to any statute of frauds other than obligations relating to capital contributions. Formation. An LLC must have at least one member for its formation. The name, address, and identity of the registered agent must be included. The operating agreement should indicate whether the LLC is managed or managed. And a person may bind the LLC in any of the following ways. First, as an agent of the LLC. Second, by grant of authority in the articles. Third, by grant of authority pursuant to a filed statement. Fourth, having the status as an agent, authority, or power. In member-managed LLCs, the members have statutory apparent authority. So, statements of authority. The new act allows LLCs to file statements of authority with the state. These statements of authority give record notice to third parties of a person's power to bind or limitations of same, the LLC. With respect to real property, the statement of authority must be recorded in the local jurisdiction. So it must be recorded in the local jurisdiction. Unless canceled, a statement of authority is canceled 5 years after the date of the statement of authority. Okay, members. How to become a member. First, the operating agreement can provide requirements. So it's the operating agreement. Second, admission may occur as a result of a merger, interest exchange, conversion, or domestication. Next, with the consent of all other members. Under the old statutes, a majority in interest was required. Now we have unanimity. Where an LLC is being dissolved and the LLC has not had a member for at least 90 days, a member may be admitted by consent of the majority in interest of the transferees. Contributions to the LLC can consist of cash, promissory notes, services performed, contracts for future services. The liability for contribution must be in writing. So it must be in writing and signed to be enforceable. Once enforceable, performance is not excused by death. Yeah. So, not excused by death, disability, or inability to perform. Distributions are made on the basis of the agreed value of the contributions. Distributions are limited by the balance sheet and equity and solvency tests. And liability for improper distributions, like that of corporations, but a member of a member-managed LLC will not be personally liable if the operating agreement expressly relieves him of the authority and responsibility to consent to distributions. So if you were advising a member of an LLC, you would want the operating agreement to expressly relieve him of the authority. Persons who knowingly received an improper distribution may be liable for contribution. Persons who knowingly received an improper distribution may be liable for contribution. Any action to recoup improper distributions must be commenced within 2 years. Okay, next, the nature of the membership interest. The transferable interest. So the transferable interest means the transferee's right to distributions, whereas interest under the previous act referred to distribution rights, voting rights, management rights, and any other member rights under the articles or statute. A transfer of a transferable interest does not cause the transferor's dissociation. The transferee is entitled only to receive the distribution. So the transferee is entitled only to receive the distribution the transferor would have received. The transferee is not entitled to participate in management or access records. Okay. With respect to voting, in a member-managed LLC, each member has the right to vote proportionate to his then current percentage of interest and profits. The voter consent of a majority in interest versus per capita simple majority is required. Unanimity is required to first amend the articles. Second, admit a new member. Third, expel an existing member. Or fourth, for dissolution. If a member has transferred his interest to a person who is not a member, the transferring member is still entitled to vote. Vote. So he's still entitled to vote. Proxies may be appointed. In a member-managed situation, each manager has equal rights in management, and an affirmative majority vote is required. Okay, but the important exception here is unless the action is taken without a meeting, then unanimous consent is required. An act outside the ordinary course of business requires unanimity. Okay, dissociation of LLCs. In addition to dissociating due to bankruptcy, dissolution and winding up, or the occurrence of an event stated in the articles or operating agreement, a member can also dissociate by voluntary express will and involuntarily by expulsion. A member can dissociate wrongfully or rightfully at any time. A wrongful dissociation can incur liability to the LLC and remaining members. Expulsion can occur as prescribed in the operating agreement or if the members unanimously agree to expel. Expulsion by unanimous agreement is only available where the LLC cannot lawfully carry on with that member. The member has transferred his entire transferable interest, or the member to be expelled is an entity which has been dissolved. Creditor remedies with respect to LLCs. In a multi-member LLC, a judgment creditor can obtain a charging order. So a judgment creditor can obtain a charging order against the judgment debtor's interest so that the company would pay the judgment debtor's distributions to the judgment creditor to satisfy the judgment. In a single-member LLC, where the judgment would not be satisfied within a reasonable time, the court may order the transferable interest to be sold at foreclosure. So to be sold at foreclosure. The purchaser acquires the entire LLC interest, not just the transferable interest, and becomes the sole member, and the judgment debtor is deemed dissociated. With respect to management, member managed is the default designation. In a member-managed LLC, all members have management authority.
Can you say that again?
Sure. In a member-managed LLC, all members have management authority. A member is not entitled to compensation except for services performed in connection with winding up. So just like a partnership there. Manager-managed LLC, managers are chosen with the consent of members, holding greater than 50% of the then current interest and profits. A manager will continue to act as a manager until first a successor is chosen, or the manager resigns, is removed, or dies, or if the manager is an entity and the entity terminates. With respect to duties and standards, first, loyalty. It includes accounting to the LLC and holding as trustee and winding up, the use of company property, or appropriation of company opportunity.
So appropriation.
Appropriation.
Thank you.
One must refrain from dealing with the company in an adverse way and refrain from competition. With respect to the duty of care, one cannot engage in grossly negligent, or reckless conduct, willful misconduct, or a knowing violation of the law. With respect to conflicts of interest, a manager member does not violate a duty solely because his conduct furthers his own interest. A transaction between the LLC and its members or managers, or another entity in which its members or managers have an interest, is not void or voidable. So it's not void or voidable because of that relationship or interest, or because the members or managers are present at the meeting at which the transaction was authorized or approved, or because their votes were counted for the purpose. If the transaction is fair to the LLC,
It's fair.
Neither equitable relief, damages, or sanctions are available. Fair means that the transaction considered in its entirety is beneficial to the LLC and its members. Records with the LLC. If it's a member-managed LLC, each member has unlimited access to information concerning the company's activities and affairs, financial condition, and other circumstances that the company knows and is material to the proper exercise of the member's rights and duties under the operating agreement. Unless the company reasonably believes the member already knows the information. Okay. The company shall furnish on demand other information concerning the company's activities and affairs, financial condition, and other circumstances, except to the extent the demand is unreasonable or otherwise improper. The duty to furnish requested information extends to any member to the extent the member knows any of the information. Okay. In a manager-managed situation, each manager has the same right of access that inure to the members. A member first can inspect and copy the current list of names and addresses of members and managers, a copy of the then in effect operating agreement, a copy of the articles, the 3 most recent tax returns, and the 3 most recent year's financial statements. A member may seek other information if first the information is sought for a purpose reasonably related to the member's interest as a member. The member makes a demand, describing with reasonable particularity the information sought and the purpose of seeking the information. And the information sought is directly connected to the member's purpose. The company has 10 days to respond to the request for information. And that's my summary of business entities.
Do we have any questions while we've got Leah?
Yes, please. Yeah. And I think,
What about insider trading? Should we?
I wouldn't focus much on insider trading. Yeah. When you get into the state and federal securities laws, yeah. I try to hit the highlights. I try to hit the highlights. I know we're getting close to the bar, so.
Anybody else? Do we have, in the back there, do we have a question or?
Oh, separate juridical entity. Separate juridical entity. So say the statutes.
Okay, let us all thank Leah very much for her
Thanks.
opinion. And I'm sure she'd be willing to hang around for a few minutes.
Yeah.
If you have specific questions that you'd like to ask her. And beyond that, again, next Wednesday is our last session for, hang on one second, I know. For those of you who are coming, if there's anybody here who's going to go underground next week, and so I don't see you, I wish you all the very best of luck. You guys have been terrific. You've been coming, you've been working, you've been doing what you're supposed to do. And as we've been saying all along, Leah and I were talking about even before the session, if you do the work, that's what counts, and you all really have been doing the work. So I applaud you for that, and I will be delighted to see you all at the swearing-in session, right?
Yeah, absolutely.
Okay, so that's it, unless you have questions for me.
And you can email me. I think my email's on the front page. So.